And then finally, I want to take a minute, turn to the city attorney. He's asked to share some information with you about short-term rentals.
Go ahead, Dan.
Hi, good evening. We have before us tonight, we're going to discuss in exec session a settlement agreement that was offered by the plaintiffs in this case. I wanted to give you kind of an update about the program and the where our program seems to be headed in the federal courts around the country. Just kind of an update. It's not really something that's appropriate for a closed session, so I thought I would share it with you during this open session. If you recall, our current STR regulations were adopted in 2016, and there were a couple of operational limitations that were placed on STRs at that time. We're focused on the residential zone, remember. Commercial zones don't have all these restrictions, but the big restrictions that mattered were minimum number of parking spaces, certain fire life safety requirements, and that there be that the owner be a long-term resident of the city. We've since amended that last requirement to be the long-term residency requirement can be met by someone other than the owner. Other cities have called it the host, the on-site host, or a supervisor, something like that. So that's how we've amended it. And what's kind of emerged in federal courts, there haven't been too many federal courts around the country that have trial courts that have addressed the Commerce Clause challenge to these kind of restrictions, but the number is growing. And there appear to be kind of two models out there. One, which started in the city of New Orleans, that required the long-term tenant to be the owner. And there, the district court and the Court of Appeals invalidated that under a Commerce Clause challenge because it was the owner. You couldn't make it was discriminatory. The Ninth Circuit addressed Santa Monica's model because the residency requirement can be met by what we'll call the host or the on-site supervisor. It's been called by a lot of these courts the adult supervision requirement. So someone has to be there, and it kind of comports with our hosted home share type model under our ordinance. So anyhow, since the Fifth Circuit rejected New Orleans went back and amended theirs to be patterned after the Santa Monica model. And since then, 4 trial courts have addressed both of these, dealing with the original Fifth Circuit case and the Ninth Circuit case. And all of them have upheld the ordinance based on the Ninth Circuit model, which is the on-site adult supervisor. That's our ordinance. So there are 4 district courts that have dealt with it, and 4 of them have upheld the model that we have here. They are the Eastern District for Louisiana, the District for Colorado, the Western District of Arkansas, and the Western District of Missouri. We haven't gotten an federal appellate decision on any of those, but there's one pending out of New Orleans. So I just want to bring that to your attention. Also, since we adopted in 2016, the the on-site residency requirement had a 7-year phase-in, and that ended in October of 2023. So as I understand it, originally had 122 STRs that rode out that period, at least to a certain extent. 47 of them remained the full 7 years. So 75 of the STRs that didn't have a long-term resident, they complied within that 7-year period. 47 of them stuck it out for the full 7-year period. And since 2016, all the residential STRs new licenses have complied with the residency requirements. And it's and what we've been able to figure, I think Dustin has tracked down some of these statistics. It appears that your two policy objectives are being achieved in terms of converting these short-term rentals to long-term tenancies. And because it appears that 60% of these 60% of the 47 are now advertised as long-term rentals. Also, the number of nuisance complaints has gone down significantly. So I don't have a good feel for the nuisance situation in Hood River, but the two policy objectives that were driving these regulations appear that they're being achieved. So
Thank you, Dan.
we can talk about the details of the settlement agreement in executive session, but I just wanted to let you know that the ordinance that we have in place appears to be surviving Commerce Clause challenges where federal trial courts have addressed it.
Thank you, Dan. Any questions? Mindful of the fact that we are going to be in exec in a little while on this. Anything else on that? Abigail, back to you. Thank you.